Mr. Robinson, I do want to make sure that you understand that you have an absolute right to be a witness in your case. You have also an absolute right to not be a witness and exercise your right to remain silent. Do you understand that?
Yes.
Now, there are advantages and disadvantages on each path. The benefit of testifying is the jury gets to hear, in your own words, what your side of the story is, what information you have that may be beneficial for you. The negative of testifying is just like your lawyers got to cross-examine the state's witnesses, they would get to cross-examine you, which they don't get that opportunity if you don't become a witness. Also, there are, if you are a convicted felon, which I understand you are, normally the state has a right to bring out not the facts of those convictions, but simply how many times you've been convicted. And your attorney has filed a motion to try to keep that out. Most likely, I probably would be denying that motion. So if you testify, the jury finds out about that. If you don't testify, they don't find out about that. You understand that?
Yes.
As regarding the issue that you got picked up from the jail, I've already agreed to your attorney's request to give a instruction to the jury that has absolutely no significance. It's not for a violent crime, and they should not give it any weight. You understand that?
Yes.
Now, certainly you should discuss this decision with your lawyers and give great weight to their advice, but you understand it's not their decision, it's yours whether you testify or not. You understand that?
Yes.
Have you had sufficient time to discuss with your lawyers this issue?
Yes.
And is it your decision not to become a witness in your case?
Yes.
Any questions about that or any of the rights that I explained earlier?
No.
All right, I'm satisfied that the defendant has made an informed decision after consultation with counsel, and we will proceed on without him becoming a witness. All right, I'll let you rest in front of the jury, but for now, you having rested, are there any motions the defense wants to make at this time?
Yes, Your Honor. Yes, Your Honor. At this time, the defense would move for a second judgment of acquittal. We would argue that the state has not met their burden as to murder in the second degree, that reasonable minds could not differ as to that, and we would ask you to issue a directed verdict.
All right. I do find that there is sufficient evidence to send it to the jury. To what extent there are conflicts in that evidence, that is for the jury to resolve. I do find that there is sufficient evidence that if the jury believes it, they could come back with a guilty verdict. So your second motion for judgment of acquittal is denied. Okay, let's discuss. Well, you want to address the objection to the principal instruction.
Yes.
I'll let you argue your motion.
Yes, Your Honor. In addition to the arguments that were made in the memorandum that was set forth to Your Honor, I would just want to highlight a few of the cases. We have Hurt v. State. It's a 2023 case, Westlaw 2506457. It's a fourth DCA case.
I'll tell you what, Deputy, if you can move that podium facing toward me, and I'll let you use the podium so you don't have to stand a mile away from me making your argument. No, they can use it when they come up, or...
All right. So, Your Honor, I would focus on the first case initially. Is in that case, the state had argued that the defendant was the shooter. There was also a co-defendant. The state did not argue at all during their case that the co-defendant could have been the shooter. Then they wanted to have the principal instruction. In part, they found that it was error, that there was no evidence presented at trial, that the co-defendant could have been the shooter. They couldn't essentially have their cake and eat it too, and they found that it was improper. Similarly, with the Roby case, which is a distinguishable case, I think that's what the state actually provided last week, which is 246 Southern 2nd, 566. In that case, we had multiple co-defendants. There was evidence produced that they were all, shooting at the victim, so that was a distinguishable case. You have multiple parties, not just a single actor. Here we have a situation where there was a single actor. As far as the evidence was produced by the state, there was no evidence presented that both the co-defendant and Mr. Robinson or some other third party participated during the course of the murder. Further, what makes it more prejudicial than the other cases is the fact that in this situation we have evidence that Mr. Robinson assisted after the fact, as an accessory after the fact. So by presenting the principal instruction, what we have is something that can confuse the jury in that they'll see that, oh, well, he assisted after the fact. And the jury may be confused and think, well, then we can convict him of that. He must have been guilty of the murder, even if they don't believe that he actually committed the act that constituted murder in the second degree. So we feel that that would be confusing for the jury. Again, since there was no evidence presented that he acted with the third party during the course of the murder, we think that it's improper based on those reasons.
Okay. State's argument.
Judge. The evidence can come from what the state presents and also can come from cross-examination of the witnesses. In this particular case, the state presented that Mr. Robinson was the sole killer in this case, but through cross-examination and even the opening statement, the defense was accusing Mrs. Tagrini as being the actual perpetrator of the crime. So my argument would be, even under Roby, a person is a principal in the first degree whether he actually commits the crime or merely aids abetting or procures its commission, and it's immaterial whether the indictment or information alleges that the defendant committed the crime. In this particular case, it wasn't necessarily alleged in the information, but through cross-examination and the opening statements, I believe it's feasible to argue principle. One of the arguments that could be made is that the jury finds that the defendant, Mr. Robbins, committed the crime and Isabella Tagrini helped him commit the crime. One of the things that was asked in the cross-examination of the medical examiner is the wounds, and is it consistent with two separate weapons? And it could be, and it could not be. So I believe it's within the jury's purview that they can consider the fact that both of them acted, maybe in concert, maybe not in concert, committing the crime. That's where it principally comes into play. If you remember, for the jury instructions, the defense asked for accomplice instruction. When you ask for accomplice instruction, you essentially ask that.
We wanted that language in the standard.
So if you ask for an accomplice, that's assuming that there would be another person or accomplice in this particular case. So I think the principal instruction is fair game, Judge. As far as how it's going to be argued in closing and distinguished, that's another option. But as far as admissibility, I think under the set of facts that we have here, I think there's enough evidence.
Can I brief response?
Yes.
Again, I would go back to the first case. If you look at page 10, it talks about how the state thought that the evidence was sufficient for the principal, because in that case there was evidence in Perch that the defendant helped clean up the interior and the co-defendant, they were both present. And again, the state was trying to say that the jury could infer that, maybe that's another theory. Maybe that both of them committed the murder together. And it's still, the 4th DCA found in this case that it was error because there was just no evidence presented that they committed the argument together. The state's trying to basically say, telling you that it was just Mr. Robinson, but if you don't believe us, maybe it was both of them. And the 4th held in the third case that was still not improper. There had to be evidence that was actually introduced, or presented to the court, that theory, and that has not been done.
And Judge, if I'm not piggybacking, but I'm looking at the jury instructions, and Mr. Stadler is not. From the updated instructions that Ms. McGuire sent me, I'm not seeing an accomplice instruction being asked for.
I'm looking for two changes.
So
I just recall that was the reason that we had this initial
No, it was one of
feedback
I think It was initially discussed, and then the defense said they didn't want it, is what my recollection is.
I just,
But just make sure it's not in there.
I don't see the specific conflict instruction in here in the updated packet. I'm gonna go through again everything, but.
Let me just, well, I think I lost my notes in my office regarding the charge conference, so I can look at that if that's needed.
I know you're reading, Your Honor, just highlight too on page 11, where it talks about that the state did not attempt to show the co-defendant was the shooter with the defendant being the principal. They also talk about that as well.
Let me address the state. I am troubled by the Pert case, which is a 2023 case. Roby, I would point out, is a 1971 case. The main holding in Pert is that merely placing someone at the scene when there are multiple persons at the scene without other evidence to demonstrate that they acted as a principal is not enough. I do understand the state's theory that circumstantially you can place the defendant at the scene at the time of the murder. But the only evidence you have is not that they acted in concert, but that all the acts causing the murder were done by Mr. Robinson. This wasn't a case where there's any evidence on the record that he and his co-defendant planned out the case or cooperated with each other prior to the murder. So, unless I'm missing something, and I'll give you the opportunity to tell me what such evidence was presented during the course of the trial.
I alluded to it during my argument with concerning the testimony of the medical examiner, Dr. Robinson. It was brought out that it could have been two separate weapons that could have been used. The state's contention is that he was there before the homicide around 2:30 in the morning came in, and that was testified by Ms. Tagliarini. Through cross-examination, obviously there was...
Now, clearly, I would agree with the state that there is sufficient evidence to place him, at least circumstantially, at the scene. The issue becomes, what evidence is there to suggest that two people worked together prior to the murder?
Judge, can you check what's up?
Sure. Your Honor, the DNA evidence, there's gloves on the scene that have both the defendant's DNA on the inside of the glove, Ms. Tagliarini's DNA on the inside of the glove, and the victim's DNA on the outside of the glove. Also, there is some some evidence from the DNA that there is DNA on the victim's fingernails of Isabella Tagliarini. So from the evidence that can be deduced is that, and the jury can deduce that they were both acting in concert. Because all the information that we see afterwards, I understand it's after the homicide, but they're working in concert. You're seeing driving.
Well, clearly, as to what actions they did after the murder, there's plenty of evidence that they worked together. The problem is there really isn't anything showing that before the murder there was any sort of plan or assistance provided to each other by the two defendants. And the state's only eyewitness says that he went in there, did the murder himself with no assistance. And whether it's text messages or other third-party eyewitnesses that saw some degree of discussion or planning between the two of them, that would probably be enough to get you that principal instruction. But what the Pert case says is mere presence is not enough.
Well, as far as I'm concerned, it did come out that through cross-examination that at one point he does ask Isabella Tagliarini that he texts Isabella Tagliarini, "You're making me nervous." It also came out the fact that, that's one of the texts.
Well,
It also
like I kept it out for the state, I made a finding earlier in terms of the context of that prior argument that it did not present enough evidence to establish a motive for murder. So that cuts both ways. I'm granting their objection to the principal instruction. I mean, ultimately, in terms of the evidence that was presented, it was either he did it or he didn't do it. And there was no evidence presented during the course of the trial that there was any planning or discussion between him and his co-defendant regarding the murder. So let's take the principal instruction out.
the accomplice instruction.
It's not an objection.
It's not in
It's not-
It's not in there?
Yeah.
Okay, so there's no discussion that needs to be on that, right? Okay. Okay.
And I believe the state agrees, I just want to check with your honor, the special instruction, we put it in the defendant not testifying. So it talks about the defendant not testifying, and then it shows that you heard evidence about.
Okay.
It's either that or standalone. I don't.
All right. Well, I'm fine either way.
And then just one other issue.
Okay.
So we had discussed the alternate juror issue, and obviously the jury could come back today. But if the evidence of caution and we're going to deliberate beyond today, I would ask that we substitute out the juror who has the issue tomorrow, just so they could come back tomorrow and we don't skip Tuesday.
I am okay with that simply because I don't want to have him rush a verdict because he's worried about missing his kid's graduation. So who's, I don't have my chart right in front of me. Who's the alternate number one?
The man, I just can't remember.
Let me see. I also need, well, let's discuss a couple other matters. How long do the parties need for closings?
40 minutes, Judge Mack.
Okay, you want to divide it how?
Twenty, whatever. Okay, so 30 seconds.
30-10, okay. 30-10, you want any kind of warning? 2-minute warning on each, okay. Defense, you've got 40 minutes for closing? Or
For about an hour, I don't know that I'll use an hour, but
well, whatever you get, they get. So you want an hour? Okay. So, how do you want to divide your hour, Mr. Sabat?
40-20, Judge.
40-20. Okay. And the same 2-minute warning. And do you have have you made the corrections for the final draft of the instructions?
I have, Judge. I'm just gonna print out. Can you just have a minute just to make sure I'm gonna go through?
All right. I mean, I'm not going to probably charge them until after lunch anyway. Yeah, go ahead. On the record. I've reviewed the proposed final draft of the charge of the court. It appears to be in order as far as containing what I said I'd read. Any other issues that we need to discuss before we can proceed with closing arguments?
Well, just in that packet, there happens to be a couple that need to come out, the evidence of other
We
crimes.
took that out of his packet.
Oh, okay.
Okay. Tell me where you want me to look on the packet if you have an objection.
They're not page numbered, but the,
Or just tell me which instruction it is, I can find it.
evidence of other crimes, wrongs, or acts, but that's only in my packet. Ms.
I took
McGuire
that
said she
out,
took it
yeah.
out.
You took that out, okay.
And then the
Defendant's.
defendant's statements also came out of, but, okay, so it looks like they're out in yours.
Look, the evidence of other crimes was located where in the packet? When it was there? Just want to make sure it's not in mine.
After aggravation of a felony by carrying a weapon.
Okay, let me just take a look. In my first read through, I did not see it. I want to make sure. Yep, in my packet, after aggravation of a felony is plea of not guilty, so it appears to have been removed. And the
And the defendant's statement comes after defendant not testifying.
okay, that is okay. Defendant not testifying is here, and in my packet, the next one is eyewitness identification. So that does not appear to be in my packet, and I've gone through it. I did not see it. So, anything else you want me to look at?
No.
Okay. We ready to proceed to closing arguments? All right, let's bring in the jury. All right, turning to the defense, are there any other witnesses that defense is going to present?
No, Your Honor, the defense rests.
All right, let me address members of our jury. At this point, both the state and the defense have now rested their cases. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. All right, turning to the state, at this time, would you like to give a closing argument?
Yes, Your Honor.
You may proceed.
Ladies and gentlemen. Good morning. I ask you to bear with me. I'm sure you noticed that I've been a bit under the weather the last couple of weeks or a week. Screaming at the hockey game last night probably wasn't the best thing either. August 5th is when Nicholis Wilcox lost his life in this case. And he lost it in a manner that's quite brutal. And the reason I mention that is because you saw the pictures from the medical examiner's office, and I'll show you some other pictures, but I will proffer to you I will proffer to you that the manner in which Nicholis Wilcox was murdered shows emotion, shows rage, and also shows a lot of strength. The amount of puncture wounds, the heavy piece of metal that was used to crush a skull, takes a lot of strength. Disposing of the body, placing it into a tarp, and putting it in the back of the vehicle also shows a lot of strength. The reason I mention that is you have an opportunity to observe Isabella Tigerini on the stand, and you can tell her height, her weight, and you can tell approximately how strong she is. Now, in my opening statement, I told you that you might not like Isabella, or you might like Isabella. It's really irrelevant. But she is a person that took the stand and told you what happened in that apartment on October 5th, 2017. She told you about a letter that was on the wall, and she told you that the letter was on the wall after and before the defendant, Mr. Robinson, went to jail. Remember, he went to jail on August 23rd, and it is her testimony to you that she started a relationship with Nicholis Wilcox once he was gone. The defendant didn't know about it because he was in jail. He got out on October 3rd, and literally 2 days afterwards, he was in the apartment. And whether it be on August 5th or whether it be 2 days before when he was collecting some of his things, that letter went missing and it was eventually found with his property at Meredith Kensick's residence. Meredith, you remember, was his ex-girlfriend, his ex-fiancée, and she testified that she picked up the defendant, Eric Robinson, from the Pompano jail, and the first place they went to is to pick up his vehicle, which was a Cadillac, a black in color Cadillac, which was parked in front of the apartment. She also mentioned that she dropped him off a couple other times where he picked up some of his things. But what's key in this particular case is that on the night of the murder, October 5th, she looked out her window. Prior to that, she looked on the couch to see if the defendant was sleeping there, and he was not. She said she has a patio, and she could see over the patio that her car was missing. Immediately, she texted the defendant, "Where's my vehicle?" He had access to his Cadillac, but for whatever reason, he decided to use her vehicle on October 5th, the night when Nicholis Wilcox was murdered. She texted him, "Where's my car?" He never got back until she saw him later that morning, and he said he went to get some drinks in the middle of the night. There were no drinks on him. There was no explanation. All we know is that he decided to use her car. There was some testimony that he borrowed her car once in a while before in the relationship. But the key is, when I asked her, did he ever use your vehicle without your permission? Her answer was no. And in this particular case, it was the first time he used her vehicle without permission, and there was no reason for it. There was no reason for it. The only reason could be that maybe somebody would recognize his Cadillac in the middle of the night while the homicide occurred. There was neighbors, Christina Ginsburg. She seemed to know exactly whose car belonged to who. She said she saw the F-150 backed up to the house, and she testified that she saw Eric Robinson. She pointed to him. There was some discussion about, well, on a previous statement, you said you didn't see Eric Robinson. She says, "I have no reason to lie. I have nothing in this for me." She testified that she saw Eric Robinson in the back of the vehicle throwing something in the back of the F-150, something heavy. But she also testified that the F-150 sped away because she could hear the engine and she could tell what it sounded like usually and what it sounded like that night. And she said it sounded like it took off pretty fast. Maybe that's the reason Eric Robinson didn't use his Cadillac that night and he used that vehicle. Maybe that's exactly the reason. Because he's known in the neighborhood, if he's lived there long enough, he knows what kind of car, the neighbors know what kind of car he drives, but this particular time, he used Meredith's car. Key. Not to mention the fact that when Detective Kendall, after the homicide, went to Meredith's residence and he picked up some things that the defendant left behind. One of them was, the letter in question, which was last seen on the wall of the apartment. Now, you're going to be given some jury instructions. Nowhere in those jury instructions does it say, or nowhere you will find, that the state, me or Ms. McGuire, have to prove motive. It's one of those things that juries often look for. Well, why would somebody do something as bad as this? And it's natural, because as human beings, we always want to know why, especially when it comes to something as heinous as murder. But if you look at the jury instructions, it's devoid of any language that the state has to prove motive. But it's nice to know that in this particular case, there is a motive. The defendant gets out of jail and he finds out that his ex-girlfriend was, in fact, sleeping with Nicholas Tagliarini. This upsets him, comes back, and does what he does. What motive does Isabella Tagliarini have to murder her person that she's sleeping with? Now let's talk about Isabella. There was a lot of talk about her different statements, and she gave a number of statements to the police. I think it was 4 or 5 statements. Some of those statements were lengthy, some of those statements were not as lengthy. And of course, the one gives statement 5 or 4 different times, there is some changes to these statements. One of the changes was when the detective confronts her with the fact that she was driving the Cadillac to the Publix instead of the F-150. Originally, she said we were driving the F-150 with the body in the back. Well, that wasn't the case. We saw that it was a Cadillac that was being driven. And I asked her about that, and all the other inconsistencies as well. The fact that she had a phone, the fact that she had a purse, and I even stopped the video at the Publix for you to show that she did have a phone. She was holding hands with the defendant, Mr. Robinson, and in fact, at one point, you saw it. She hugged him in the aisles of the Publix. When you see them at Big Lots together, they're together. But one thing I want you to see, and you can ask to watch the videos over and over again. You can ask for readbacks. All of this is available to you. But if you want to watch the videos again, we will queue them up for you, and we will play them for you, because I want you to notice and I want you to watch the body language of Isabella Tagliarini, and I want you to watch the body language of this man sitting right here. If you see her at Publix, her hands are always like this. Even at Big Lots, she's holding it close to her. Maybe you didn't catch it. And if you watch it again, please do. Watch her body language. And watch the body language of that man sitting right there in front of you. Who's making all the purchases at Big Lots? In cash? Mind you? Who's making the purchases? Watch the video. Watch the body language. Because as much as we don't like the things, or some of you might not like the things that Isabella Tagliarini did afterwards, going to the dump with the body in the back, going to the Everglades, being at Publix. And I asked her, why didn't you just leave? You're at Publix. Why don't you ask the cashier, call the manager? She testified that she's here alone in the United States, that she just saw this man bludgeon death, her new boyfriend, in the very bed that she was sleeping in. And when she says, I was scared of what he was going to do, view her body language and consider it, ladies and gentlemen. In the defense's opening, they used the language, strange behavior for someone that's innocent. That's the language that they used. I'm assuming to describe the actions of Isabella Tagliarini. But let's talk about other people in this courtroom, because we heard a lot about Isabella Tagliarini. We heard about, her statements. We talked about, things she might have said and that she left out, the phone, the F-150. Well, let's talk about another person that's in this courtroom right here, right next to me, Mr. Robinson, and his actions. Because one of the things that we're not going to ask you to forget or not consider is your common sense. We're talking about a person that's driving around in the victim's F-150, going to the dump of all places, giggling. Watch the video. He giggles at one point. What's so funny? Inside the F-150, we have receipts from the dump. And there might have been some question as to weight. How much the vehicle weighed before, how much the vehicle weighed afterwards. He was charged the minimum. So it was less than 100 pounds that he threw away. And if you watch the videos, there's a camera that shows right above the pickup truck. You can see what's in the bed of the pickup truck. You can see a tarp, the body, and you can see some garbage bags. And as he's leaving, those garbage bags are gone. That's what it's throwing out. We heard the testimony from the manager saying that it's not so easy to get rid of certain things in the dump, such as oil, such as certain chemicals, and he even said bodies. And I asked him why. He said, well, there's people looking out. That's what they do. They're lookouts. And if you remember from the video, the defendant, Mr. Robinson, when he approaches the window, there's some discussion between the person that's checking him in, and he doesn't know the procedure. And the guy says, oh, this is your first time. This is how it works. Give me your driver's license. And he's kind of like fidgeting around, and he gives him the driver's license, and you hear the guy say, well, okay, Eric, this is how it works. Here's the map to the dump. Mind you, there's a picture of the map that was found in the F-150 afterward. And this is what you have to do. As they're leaving, use your common sense again. With the tarp, with the body, still in the vehicle. Where is the next stop? Naples. Are they looking for good restaurants on 5th Avenue, or are they looking for the Everglades? And you can see the phone, the testimony from Detective Zeller. You can see them tracking together. And you can see them turn around afterwards because there was no good spot. And where does the body end up? Very close to where it started, in Plantation. If you listen to the video on the dump, it has very good sound, very good audio. And one of the first things the attendant asked the defendant is, what city? He doesn't say Plantation. He says Fort Lauderdale. Like it's going to deceive anything. That was before the attendant asked for his driver's license. And as they're leaving, there's more giggles, and he's asking for the Everglades, and they have a discussion. After they leave the Everglades, as far as the timeline's concerned, Isabella testified about the timeline. She was a little bit confused. She testified that she did take some Xanax, and that at one point they ended up at Big Lots, at one point they ended up at the Walgreens, and at one point they ended up at the house when they started painting. Now, let's talk about DNA. The DNA will show that, and it did show if you listen to it, and you can ask for a readback if you missed something. You're going to hear that the victim's DNA was found on the defendant's shoes. When he was arrested, they take his shoes, and they compared the DNA, and some of the victim's DNA was on the shoe. You're also going to find that there was a glove on the inside of the apartment. Right here. The yellow one right here. That was collected. And why is that significant? Because on the inside of this glove, we find the DNA of Isabella Tagliavini. Well, she lives inside the apartment. That's not unusual. Maybe she used the glove before, or maybe she helped him clean up. She said she helped him clean up. But we also find the DNA of Eric Robinson on the inside of the glove, showing that he was there and he used the glove. On the outside of the glove, we have the DNA of the victim. So we have all three of them on theirs. And especially what's important is the fact that Eric Robinson's DNA is on the inside of a glove used to clean up the scene. And of course, there's other photographs of paint that was used to cover up. Speaking of strange behavior, as defense told you, strange behavior for an innocent person, I think that's exactly the words that she used. We heard testimony that Eric Robinson, out of all the things that he's involved in this particular case, moving the body, going to the dump, going to other places, the Everglades, within all this, he finds time and the necessity to have sex with Isabella Taggerini. That's a little bit odd too, isn't it? Let's say that story is that the defendant, Eric Robinson, arrived on scene and Nicholis Wilcox was already dead. And as the defense said, he doesn't have unclean hands. Those are the words that she used, unclean hands. And then he arrives on scene and is encountered with a body, and he says, well, you know what? I just got out of jail, and the first thing I'm going to do, I'm going to help you dispose of this body. But before we get to that, let's have sex. Put on some lingerie and let's have sex. In the midst of all this craziness, he finds the time, and he finds the necessity to have sex with Isabella Taggerini. And she testified to this. She says, yes, I had sex with him because I was scared. I felt like I need to appease him because this is the person that woke me up and he's butchering my new boyfriend. So I felt that I needed to have sex with him. I didn't want to have sex with him, but I felt I needed to have sex with him. But I'm talking about his behavior, his strange behavior, and the fact that he finds a time, and again, like I said, the necessity to have sex with her, that was so important to him. Now, part of the instructions that you can be given is murder in the second degree. To prove the crime of murder in the second degree with a weapon, and again, a weapon could be anything. We heard testimony that Isabella heard or saw there was a metal object. She described it as a crowbar. Crowbars can have a sharp end at the end of it, and sometimes they're curved on the other side, and they can definitely do the damage that was inflicted on the victim. To prove the crime of murder in the second degree with a weapon, the state must prove the following three elements beyond a reasonable doubt. One of them is that Nicholas John Wilcox is dead, and we have a stipulation to that. You can put a check mark right next to that. The death was caused by a criminal act of Eric David Robinson. And again, we have a testimony from Isabella Taggerini, and we have DNA and his actions afterwards, which speak to his involvement in this particular case. And three, there was an unlawful killing of Nicholis Wilcox by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Without regard for human life. Rage, strength, motive, and opportunity, all of which the defendant, who's sitting right there in front of you, possessed on October 5th, and did this to Nicholis Wilcox. Motive, intent, opportunity, and the ability to do so was all present. Now, there are lesser included crimes. Now, you might be asking, well, why not murder in the first degree? That's not within your purview. This case was charged as murder in the second degree. The state does not need to prove the specific intent that Eric Robinson intended to kill Nicholis Wilcox before he did so. A lesser included crime of murder in the second degree is manslaughter with a weapon. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. First one is that Nicholas John Wilcox is dead. Again, that was stipulated to. You can put a check mark right there. And the second element is that the defendant, Eric Robinson, intentionally committed an act or acts that caused the death of John Nicholas Wilcox. We certainly have that here. But I profit to you, ladies and gentlemen, that it goes beyond just series of acts. It's a depraved human mind that did this. One of the things that came up during the testimony of the DNA analyst was the name Paul Smith. Some of you might have heard it, and you're thinking to yourself, well, she's talking about Nicholas Wilcox, she's talking about Isabella Taggerini, she's talking about Eric Robinson, and then this Paul Smith pops out of the blue. Well, you remember when Marjorie Hanlon, she was the older lady that's retired from the crime scene, she was testifying that one of the officers by the name of Paul Smith accidentally touched a piece of evidence in the crime scene. So that's where Paul Smith comes out, because someone inadvertently touches the crime scene. They want to take Peter's DNA to make sure that it's excluded, so it doesn't come to somebody out there. Okay. Now, one of the things that has already been explained to you, and I'll refer to it again, is what the lawyer's saying is not evidence. You should consider it to guide you in your decision. And that goes a little bit further than that, because, I believe Ms. McGuire mentioned that when we were picking a jury, is first of all, use your common sense of what they're thinking. And the other thing is, what the lawyers say in the questioning and in the cross-examination. The question is not evidence. The answer is evidence. And that makes a difference, because a lot of times the questions allude to something and the answers say something else. So keep that in mind when you deliberate. Now, I'm not going to go through all the jury instructions. I went through the ones that I think are appropriate, but I'm going to have another moment to speak to you, okay, after the defense is, and I'll have an opportunity to answer and or rebut any of her arguments. But keep in mind, what she's doing in closing, that the motive, the opportunity, the intent was all present as it pertains to the defendant, Eric Robinson, and it's the state's posture, it's the state's proffer that he did brutally murder and butcher Nicholas Wilcox on October 5th, 2 days after he got out of jail. Thank you.
Right. All right, we'll take a 5-minute break, sure. Jury can leave your notebooks at or by your chairs. The deputy will take you in the back. All right, we're outside the presence of the jury. You may be seated. We're recessed for 5 minutes. Back in session. Let the record reflect the defendant is present along with his counsel and counsel for the state. Are we ready to continue?
Yes.
Yes, sir.
Okay. All right, let's bring in the jury, please. Everyone, please be seated. We're ready to continue. At this time, would the defense like to give a closing argument?
Yes, thank you.
All right, you may proceed.
Good morning, everyone. So as I told you in opening statements, there would be a lot of evidence that we were agreeing to, right? That Mr. Robinson came over, that he assisted his ex-girlfriend, Isabella Tagliarini, in helping to clean up her crime scene and helping to dispose of Mr. Wilcox's body. And yes, I used the words clean hands. He does not have clean hands. Well, much of the state's presentation of their case confirmed exactly that and nothing more. I want to acknowledge that what happened in the aftermath of Mr. Wilcox's death was pretty horrible, right? You're hearing a lot of evidence just talking about the body, but that was a human being. And I want to just acknowledge that nobody deserves to be thrown away like trash, right? It's a terrible fact that you heard, and I just wanted to make sure I said that. So the only evidence that the state presented to you to try and convince you that Mr. Robinson is the one who killed Nicholis Wilcox came from Isabella Tagliarini. As I told you in opening statement, there would be no direct physical evidence that would link Mr. Robinson to the actual murder. To the cleanup, yes, but not to the murder. So let's talk about some of the physical evidence for a minute. There's not really much to talk about here. You heard a lot about certain items collected, certain items swabbed, certain items not swabbed or processed. For example, the entryway to where Ms. Tagliarini says Mr. Robinson came in through the back door. Seems like that would be a really smart place for crime scene to process, to lift prints, to try to obtain DNA. You didn't hear that. You heard a lot of items that were collected, right? Ms. Tagliarini said he was wearing black sweatpants. Ms. Kensick talked about the black sweatpants, or maybe Detective Kendall, that these were taken from the home of Ms. Kensick, but you heard nothing about them. Not one drop of Mr. Wilcox's DNA were on these pants that Mr. Robinson was wearing. You heard about DNA under Mr. Wilcox's fingernails, absent of Mr. Robinson's DNA. But Ms. Tagliarini's DNA was under his fingernails. And you heard about Ms. Kensick's car that was processed, swabbed, the car that the state is saying that Mr. Robinson surreptitiously drove over in the middle of the night and then drove back to Ms. Kensick's house. Not one drop, not one skin cell, not one bead of sweat obtained from that car. Mr. Sapak just talked to you about the glove. That proves exactly what I told you, and nothing more, right? Mr. Robinson's DNA is on the glove, inside the glove. Ms. Tagliarini's inside the glove. They're both cleaning. Okay, fine, right? Well, Mr. Wilcox's DNA is on the outside of the glove. Of course, they're cleaning up where there was blood of Mr. Wilcox. And then the feet, the footwear, the victim's blood on the bottom of the shoes or somewhere on the shoes. Right, cleaning up a crime scene. So nothing that the state presented to you by means of forensic evidence points to anything that they are alleging. There is DNA, however, from a sperm fraction in the second bedroom proving that Isabella and Eric Robinson did have sex at some point during October 5th. So I want to go over the law briefly again so that as I go through the evidence, I can kind of put it into context with you. For me, it helps to actually see it. So I'm putting up the instruction of plea of not guilty, reasonable doubt, and burden of proof. And Judge Bober is going to read these to you once we are done with closing arguments. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. We talked about this a lot. We don't need to talk about that too much more. The presumption stays with him. Whenever the words reasonable doubt are used, you must consider the following. Now, here's the definition. It's a little bit wordy, right? Our legislature likes to write things a little bit wordy. But essentially, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond a reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Then we have a reasonable doubt as to the guilt of the defendant may arise from the evidence itself, meaning the evidence the state presented to you, conflicts in the evidence, or the lack of evidence. Now, in addition to the reasonable doubt instruction, I want to talk to you about Mr. Robinson not testifying. Some people are not okay with that, and that's why they are not picked as jurors in a criminal case. All of you swore that you would uphold the oath that you would not consider whether he testified, you would not hold it against Mr. Robinson, you would not consider it as evidence of guilt, that you would be not bothered by it at all, and that you would look to the government alone to prove the case. I know it seems like a while ago, but at the beginning of the case, Judge Bober talked to you all about the information, the charging document. And he read the charges and said that it's kind of like a traffic ticket, right? It informs a defendant what they are being charged with. Well, Mr. Robinson is here saying, I am not guilty. I entered a plea of not guilty, and that is why we're here for a trial, and that is all that needs to be considered by you all. So let's start with talking about Isabella Tagliarini's testimony and why it is not credible. And remember, you are the fact finders. You listen to the evidence, you listen to the people, you look at the evidence, and you decide whether you believe it, partially believe it, don't believe it at all. So how do you assess Ms. Tagliarini's testimony as jurors? Well, as the state just said about common sense, right? You don't check that at the door. We all in our daily lives assess people's credibility, right? You meet somebody, you kind of size them up, and you assess their credibility in your daily life. So that's something that you would use. And assessing someone's demeanor can be very different from one person to another. One person can say, I thought this, another person says, actually, I interpret this a different way. Well, there's also a jury instruction about how to interpret or how to assess somebody's credibility. And you'll see that one as well when you get the packet, and you'll hear Judge Bober also go over it. Okay, so here are the factors that you're to consider when weighing the evidence of a witness. Did the witness seem to have an opportunity to see and know the things about which the witness testified, right? Did the witness seem to have an accurate memory? I submit to you, Ms. Tagliarini did not. Was the witness honest and straightforward in answering the attorney's questions? I submit to you, Ms. Tagliarini was not. Does the witness have some interest in how the case should be decided? Ms. Tagliarini does. Does the witness's testimony agree with the other testimony and other evidence in the case? Her testimony does not. Has the witness been offered or received any money, not money, right, but preferred treatment or other benefit in order to get the witness to testify? Yes, she did. She got a reduced charge. And did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Yes. Literally, almost every single one of those apply to Ms. Tagliarini. And then at the end of that instruction, you'll see this other part, which says you must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, or has been promised immunity from prosecution, or hopes to gain favorable treatment, etc., etc. Specifically written for circumstances like what we have in this trial. Ms. Tagliarini, as I told you in opening, was charged with a more serious crime. Her charge was reduced, and she's awaiting sentencing, hoping that what she did for the state in this trial gets her no jail time at all. So let's talk about the marriage letter, love letter contract for a minute. And I know sometimes when you all are sitting there and either me or the state is asking questions, sometimes you think I'm going one way, but this is my time to kind of explain why I was asking those questions. I don't care when Ms. Tagliarini and Mr. Wilcox started dating or being in a relationship, whether it was before Mr. Robinson went to jail or after. That was not the point. It was not to try to say she's a cheater. The reason I was confronting her with that is because she swore to tell the truth to you. And right out the gate, she's already giving you completely inaccurate information. You hear Robinson goes to jail on August 23rd. She tells you they don't even get into a relationship, her and Nick Wilcox, until 3 weeks later, but her strange marriage contract thing was September 3rd. So obviously those details are not correct. Again, her testimony not matching with other evidence in the case. Now you've seen that marriage contract, and you've heard that it winds up at Ms. Kensick's house. But you've also heard that, first of all, Isabella Tagliarini supposedly never noticed it was gone, right? It was taped above their bed. Never noticed it was gone. And that Mr. Robinson had a lot of belongings from the house over at Ms. Kensick's. He was driving the F-150 around, he and Isabella, all day on the 5th. And there were a lot of handwritten notes, a lot of papers and documents of Mr. Wilcox's inside that truck. So it's pure speculation on the part of the state to say that it got to Ms. Kensick's house by any other means. So let's assume they wait a couple days to get together, Isabella Tagliarini and Mr. Wilcox. So let's say they get together August 25th. About 1 week later, and I'm just throwing that date out there because it's close to when Mr. Robinson goes to jail. Give her the benefit of the doubt that she waited, 48 hours before she got into another relationship. September 3rd, so maybe about a week later, they're drawing up this contract. They are passionately and madly in love, presumably, that they are now promising to marry each other the following month and promising to have children together, right? This is an extreme high in a relationship. Now fast forward to September 22nd. Now we're going from here, this extreme high, to this extreme low, where they are already in a fight that is so intense that Ms. Tagliarini and Mr. Wilcox are separated, and Ms. Tagliarini has to go or goes to a hotel. Sounds like the honeymoon period is over very quickly. Then you hear that around October 3rd, I was asking Ms. Tagliarini about a text. If she recalled a text that she had sent to Mr. Wilcox, something about him lying and not being who she thought he was, right? And then he dies 2 days later. Again, serious highs and lows in a relationship that was maybe a month and a half. Only Isabella Tagliarini and sadly Mr. Wilcox can tell you what happened in that bedroom on October 5th that caused her to murder her boyfriend. She is the one that can tell you that, and clearly she is not going to. But what we do know, from the objective facts we have, is that their relationship was volatile. So I want to comment on what Mr. Stafak said about motive, that they don't have to prove motive, but they have one here. Well, do they? Because have you heard any evidence whatsoever that Mr. Robinson wanted Ms. Tagliarini back? Have you heard that he from the jail when he was there, remember, for a nonviolent offense. And you'll be instructed that that should not come into your deliberations at all. Have you heard that he was calling from the jail to Ms. Tagliarini? That he was sending text messages, that he was having when he got out, other people call, that he asked Ms. Tagliarini to pick him up from the jail? No, sounds like he moved on. He had Ms. Maritis Kenzek, pick him up, and he was staying with her. Ms. Kenzek didn't say anything about Mr. Robinson mentioning about Isabella being with somebody else, how he was upset, how he wanted to see her, nothing. He went and picked up his gray Cadillac outside of the house. Now, Ms. Tagliarini claims she didn't know that Eric Robinson had gotten out of jail. Think about that for a minute. His Cadillac has been parked outside the house for about a month, and then it leaves. She didn't put two and two together that maybe Mr. Robinson had gotten out of jail. So the state's alleged motive as to why Eric killed Nicholis Wilcox is pure speculation. So back to Isabella's testimony. If she truly saw and experienced what she says she saw and experienced, it would be clear as day, right? Because the truth doesn't get messed up. When something happened and you're telling the truth, details don't get mixed up. You don't leave major things out. You don't say the wrong thing, because the truth is the truth. And so you've heard that she started out just giving some information that Detective Haynes would just swear her in. And then it started to unfold when he started to realize there was more going on there, and he started to issue her Miranda warnings because he suspected she had more involvement than she was letting on. And think about the omissions for a minute. The things that she left out seem to always help her version of the story. She's not leaving out things that are insignificant. She's leaving out really important factors. For example, she plays the role of the victim and the captive really well at first with Detective Haynes. Now, if she says, he took my phone the entire day and had no way to get a hold of anybody, he's more likely to believe that she experienced what she said she experienced. If she says, he never let me leave his side all day long, Detective Haynes and other law enforcement officers are more likely to believe the story that she is telling. She tailored what she told them intentionally to fit the narrative she wanted them to believe. For example, she intentionally, and told them, I intentionally lied about the fact that I had used alcohol or drank alcohol that day because I didn't think you would believe me about what I was telling you. So these are the things that are going on in her mind. Not, let me tell the police everything, but what should I tell them in order to fit my narrative? Her statements, now think about this. She says that Mr. Wilcox died in the early morning hours of October 5th. You heard that right at the beginning, he's gasping for air. Sorry, one second. And that she sees blood. Then he's wrapped in 2 tarps. He's wrapped in duct tape with belts. He's wrapped in this very tight wrapping for hours and hours and hours. But at night on October 5th, when she's telling or talking to Detective Haynes, she once again plays the captive or the victim card and says, is he still alive? The evidence is pretty clear that there was no way that Mr. Wilcox was still alive at that point, sadly. And Detective Haynes told you that she wasn't straightforward. It wasn't as if 2 days after the 5th, Isabella Tagliarini picked up the phone and said, oh wait, here's another detail I just remembered. It's not how it happened. Detective Haynes, who I had to call as a witness, right? The lead homicide investigator who orchestrated this entire case was called by the defense. And he told you that certain details are coming out when he is confronting her with the truth. For example, her driving, or them driving the F-150 with the body in the bed of the truck to Publix. Well, he shows her the video, not true. Having her phone, not having her phone all day. Oh, Ms. Tagliarini, seems like you're on the phone here, texting with Mr. Robinson while he's over at the courthouse. Oh, right, I must have had my phone. Seems implausible that that is a detail that someone would forget. So Ms. Tagliarini says that she's sleeping in bed when Mr. Robinson comes in and is killing Nicholis Wilcox right next to her, and she does not wake up. Does not wake up. The only time she wakes up, she says, is when Eric Robinson is on top of her with both of his hands. So think about this for a minute. Whatever happened to Mr. Wilcox at that point sounds like he is in very bad shape, because Mr. Robinson doesn't even need his hands anymore to deal with Mr. Wilcox. So he's moving to Isabella and supposedly putting one hand on her neck and one hand on her mouth. She can hear the sounds that she described, and she can see blood, right? But again, by the time that's done, or while that's happening, she's sleeping. A detail like that, or the scenario that she describes, does not seem to make any sense whatsoever. And she sees Eric Robinson, and she makes like a swinging motion with her hands, hitting Mr. Wilcox, saying, "Die, die, die." This is really important, because she never said that before. In fact, Detective Haynes verified that when she talked about what happened, she said she did not see it. That when they're in bed, Mr. Robinson is shielding her eyes, and when he brings her outside, he's keeping her from seeing what's going on. But here in court, she's telling you that she witnessed it with her own eyes. So let's talk about the Xanax for a minute. Mr. Saback said, yeah, she took Xanax. No, that's not what she said. She said Mr. Robinson forced her to take Xanax, right? She's prescribed 2 milligrams at a time by her doctor. And she claims that, think about this, Mr. Robinson is trying to get her to help with everything that happens after the fact. But he gives her 8 milligrams, 4 times her dose. And she's drinking alcohol, and then she's supposed to be able to be clear-headed enough to be able to help him after the fact. So think about some of the things that Ms. Tagliarini did maybe right after or shortly after she supposedly had to take the Xanax. And think about the time, a point where Ms. Tagliarini says that Mr. Robinson kills Mr. Wilcox, but then he goes back to the house in Ms. Kensick's car. So there's a period of time, and this is the period of time that these texts are between the two of them, right? Mr. Robinson leaves her with her phone, where she's telling him, come home, I'm your wife, proposes to him, and then tells him, I'm going to shower. And that's what he supposedly says, put on some lingerie, right? So we see Isabella Tagliarini, once Mr. Robinson supposedly gets back to the house and they go to Publix, the Publix down here, not the Plantation Publix. You see her another thing that had to come out after Detective Haynes confronts her. She alone is driving the Cadillac up the ramp into the Publix. It's a pretty narrow lane that has kind of a sharp curve. Watch the video. Nothing about that screams that she's intoxicated by any stretch on 4 times the amount of Xanax that she normally takes in alcohol. And then you see her walking around Publix, seemingly fine. Like, nothing is wrong. I disagree with Mr. Stapat's assessment that she seems scared. Not at all. She's walking through the aisles. She's talking to Mr. Robinson. Seemingly fine. Now, again, we're not hearing her in that video. It's surveillance video. You're not seeing a whole lot. But watch it again. Does that look like somebody who had just consumed that much medication and alcohol? So again, does testimony agree with other evidence in the case? No. And not to keep talking about the phone again, but there are a few things I want to say about her not having her phone. Not only is she not mentioning she has her phone, she's not mentioning to them at first that she's left alone throughout periods of the day. Now, if Ms. Tagliarini was so frightened about what she had just seen, here's the time to use common sense again, ladies and gentlemen. How many opportunities do you hear about throughout this trial where Ms. Tagliarini could have gotten help, could have called for help, could have driven for help? The Publix down here has police officers everywhere. We are in the courthouse complex. So not only could she have gotten the police at the Publix, she could have taken Mr. Robinson's car to the Fort Lauderdale police station, anywhere to get help. She's driving the car later on by herself, Eric Robinson's Cadillac, to Walgreens, again with her phone. So many opportunities for her to call the police, and she does it. Why? Because she knows she killed Nicholis Wilcox, and she's trying to hide it. So she's not giving up information freely. And again, when she's alone after about 5 o'clock, who do you hear she calls? Does she call the police? To tell them what happened now that she's finally alone? No. She calls her ex-husband, Nick Tagliarini. Again, this is a woman who keeps men in her life so she can use them when she needs them, right? In her web. So there are other things I could get into, certain omissions, certain things she said that were inconsistent. That she touched the body, didn't touch the body, left out synergy, left out the landfill, a lot of things that came about when the detective started investigating. But I know you all heard that evidence. I don't need to rehash all of it. What I do want to address is what may be, maybe not, a burning question in your minds, which is, if Isabella Tagliarini called Mr. Robinson, or however messaged him to come over and help after she killed Nicholis Wilcox, well, Ms. Newman, where is that evidence, right? So I want to start again by saying, of course, the state has the burden of proof, but I can understand why you would want that evidence, because I'm the one that raised that that's what happens. Well, I wish I had that evidence to show you, but I don't. And why don't I? Because the Plantation Police Department, just like not swabbing the doors and just not collecting certain other items of evidence, they failed to collect all the means of communication that they could have. I don't work for the government. I can't tell them what to collect, how to collect it, right? I get what I get once everything is over. So I talked to Ms. Tagliarini and others about her iPad, right? So her iPad is in her bedroom. There's also a desktop computer. She said, I think it was a mini Mac in the house that may have been used by her, but we have no idea. Not collected, not processed, just like the iPad. Then there's the phone that was on the dresser. Let's hope this wakes up. My lucky day. All right, so here's a photograph of a phone on the dresser, right? You can see that it's on the dresser. You can see a pink sleeve underneath it. And this is Mr. Wilcox's Motorola phone that they recovered. As you can see, it's face down and it's on some type of linoleum floor, right? Well, where's this phone? What happened to this phone? This Android phone. So multiple means of communication that are gone. Poof. Nowhere to be found. What you did hear was that they collected Mr. Wilcox's Motorola phone, that they collected some Android phone at Ms. Kensick's house. You didn't hear anything about it other than that they collected it. There was a phone with Mr. Robinson when he was arrested in the Cadillac, another Android. The iPhone, which was Isabella's, that you heard, she told them, sure, you can go in it, the phone she's been using all day long, and then all of a sudden she's at the police station and it's no longer accessible, right? You heard about that phone. And then I said the Motorola that was Nick Wilcox's. So you saw no evidence from any of these devices. The only evidence that you heard was from Detective Zeller, who got involved in this case. It's from a different department a month ago, maybe 2 months ago. His testimony, like much of the testimony in the case, was yes, Eric Robinson and Isabella Tagliarini are around all day, going to this store, that store, what have you. So he shows you the cell site locations, and he tells you that when he compared the call logs, now we're talking about just phone numbers, between the two of them, there's one call he sees later on in the day, on October 5th, but no other call. That tells you nothing because we know that they communicate via other means. For example, Facebook Messenger. You heard, again, her messaging him, come home, the married stuff we talked about. She says, I need a drink. So, as I said in opening statement, the Plantation police officers and the detectives in this case rushed to judgment. Isabella Tagliarini thought that she could manipulate Detective Haynes, another man that she could get one over on just like she does all the other men in her life, but she was mistaken because Detective Haynes didn't just take her word for it, and you've heard a lot about that. Eric Robinson's arrested for murder on October 5th. There's no going back at that point, right? So now we have a week and a half later, Ms. Tagliarini is arrested for accessory after the fact. And I want to talk about that charge for a minute because it's exactly what I'm telling you Mr. Robinson was, but I want to make it clear, in this trial, that's not something you're looking at to decide. The only charges in front of you are that the state has charged Mr. Robinson with murder and murder alone. And there's a lesser included offense of murder, but that is it. So if you have a reasonable doubt in this case, a reasonable doubt arising from the evidence itself, Ms. Tagliarini, a conflict in the evidence, Ms. Tagliarini, or a lack of evidence, which is abundant, then you must find Mr. Robinson not guilty of murder in the second degree. Thank you.
All right, rebuttal argument.
So, we heard the defense closing, and as I thought would happen, it happened. Ms. Newman claimed that the honeymoon period was over, and that Isabella Tagliarini is this black widow that captures men, molds them to what she wants them to be molded to, and Eric Robinson essentially is a victim of her manipulation. And in fact, let's give him a medal because he was a good Samaritan.
Objection, Your Honor, improper.
Let's move on.
He, of course, showed up to Isabella's apartment and did whatever a good ex-boyfriend would do 2 days after getting out of jail. He got on his knees, took the bloody body of Nicholis Wilcox, rolled it up in a tarp, and threw it in an F-150, and did the grand tour of Broward County with the body. That's what they want you to think. He's a good Samaritan. The real person who did the deed is Isabella Tagarini. Because as they say, all the evidence is after the fact, after the body was disposed of. All those things are okay. He's a good Samaritan. It doesn't matter. Because it doesn't go to the homicide as the defense says. Well, let's talk about a couple things that are kind of important that go to motive, opportunity, and the ability to do so. Let's talk about communication between Isabella Tagarini and the defendant, Eric Robinson. I asked two separate people the same question. Well, not the same, slightly different. Jonathan Zeller, he's the person who did the Tower records. And of course, Tower records, ladies and gentlemen, talk about communication, text messages, phone calls, not digital communication, WhatsApp, Facebook Messenger. There's so many of them, correct? Now, he said that the first communication between either party was at 5 p.m. after the homicide. We're talking about cell phone communications. That's what he testified to. Because we have the records and their evidence of Isabella Tagarini, and we have the records of the defendant, Eric Robinson. 5 p.m. afterwards. What else does that presentation show? It shows Isabella, up to the homicide, moving every day to Palm Beach. The defendant stayed in Broward County, around the same area where Miss Meredith lived, within a mile of the homicide location. And we see Isabella Tagarini moving up and down. Well, why is that important? Well, she testified that she was working with Mr. Wilcox doing construction. I asked her where, and she said in Palm Beach. So as she's in Palm Beach, the defendant is showing up to pick up his stuff right after he gets out of jail. First he picks up his Cadillac that's working, then he picks up some stuff inside the house. Then I asked Detective Haynes. I said, and you can replay his testimony, you can have it read back if you like. I asked him, Detective Haynes, and the defense made a big deal out of it. State didn't call the lead detective. Not unusual, ladies and gentlemen. Lead detectives, they guide the investigation. They talk to various people. But when it comes to testifying in open court...
Objection, Your Honor. Facts, not evidence.
Ladies and gentlemen, this is not evidence. It's argument of the lawyers, and you are not to treat it as evidence. You may continue.
Lead detectives cannot testify as to what other people said during the investigation. That's called hearsay. That's why you have the actual people, like Ms. Ginsburg, take the stand for you, instead of having Detective Haynes regurgitate what Ms. Ginsburg would have said. That's hearsay. Well, anyways, I asked Detective Haynes, other than the Tower records, text messages, and phone calls between the defendant and Isabella Tagarini, did you look at other things? He said, yes. One of the things that we looked at was Facebook Messenger, which it appears that the first time they were communicating was again in the morning of the homicide, after the actual homicide occurred. After Ms. Ginsburg saw the defendant playing around in the back of the F-150. Now, the defense would like you to think, well, maybe she was using the laptop. She went out of her way, turned on the laptop, and she was using WhatsApp on the laptop. Everything's in a cloud. If I use my Apple iPad to Facebook Messenger somebody, guess what? It shows up on the cell phone as well. It's all part of the same app. And why would she be using a different app? Then halfway through the day, after everything is done, she switches to Facebook Messenger. Doesn't make any sense because there was no communication between the defendant and Isabella Tagarini. It started afterwards. After the defendant showed up, she wasn't expecting him because he was in jail. Let's talk about other evidence of intent, motive, opportunity to do so. I'm not talking about driving to the dump and all that stuff, which is telling, ladies and gentlemen, but let's move on to something else. The fact that he changes his car, that's really huge. Prior to the homicide, we heard from, again, Ms. Kensek, and she says in the early morning hours, he uses her car to go to the homicide location. Why does he think of using a different vehicle, the defendant, if he's just there to check up on Isabella? Why would you use a different vehicle? Use your common sense. That thought, what he was going to do, was already ingrained in him. And he decided to use her car because it's not expected. The neighbors wouldn't see it. But unfortunately for the defendant, Eric Robinson, he was seen by Christina Ginsburg playing around in the victim's F-150. How the note got there, pure speculation. Why? Those are some of the things that defense counsel touched in closing argument. It's a love note between Isabella Tagarini and the victim, Mr. Wilcox. Whatever you might think of the note, how silly it is, how stupid it is, it doesn't matter. It was enough to get this man's anger going. It was enough for him to get riled up, to use a different vehicle, and do this to the victim. Motive, opportunity, and ability to do so clandestinely, using a different vehicle. How did the letter end up there? Well, it's probably within some of the things that's in the F-150. No. Those things we found inside the F-150. We found receipts from the dump. We saw receipts from Big Lots. And of course, we saw the defendant paying for all that. But that letter was signed by Isabella Tagarini and the victim, and for whatever reason, it ended up in the defendant's property. That particular letter. Out of all the letters that could have been in the apartment, that particular one is a very telling one. Motive, opportunity, and the ability to do so. And as much as Ms. Newman wants to paint Isabella Tagarini as a manipulative person that manipulates men, is there any evidence of that? Why would she want to kill Mr. Wilcox? Because they had an argument? Or is that letter found in the defendant's property a very telling piece of evidence? The other thing that was a little bit telling is when the defendant shows up at the residence, he asks her to do certain things, and Ms. Newman said, well, Isabella never saw the actual hitting of the body, but she testified she heard it. It sounded like a metal piece hitting the body, creating the damage that I just showed you. And when I asked her to describe it, she said, well, it looks like kind of like a crowbar. But then she goes on to say that the defendant asked if Nicholis Wilcox and Isabella used condoms. He was very interested in that. Well, did you guys use condoms? And again, we get into the sex right away. The body's still in the apartment, and the first thing on his mind is, let's have sex. Body's next door, but it's very important for him to have sex with Isabella Tagarini. again, I'm not gonna belabor it, but look at the videos, ladies and gentlemen. I implore you to look at the videos, and as much as I pointed out the fact that they're hugging and they're holding hands, look at the body language of Isabella Tagliarini. Look at the body language of the defendant. I think it's very telling. And I think if you consider all the evidence and you sit down and use your common sense, we have the defendant driving around Broward County in the victim's vehicle. His DNA is inside the vehicle. We have his DNA on his shoes. We have DNA inside the glove. And as far as Ms. Newman says that there is no evidence prior to the homicide of the defendant's motive and ability to do so, the switching of the vehicles is very telling. The fact that he has an ability to use his own Cadillac and chooses to use somebody else's vehicle is very telling. The fact is that the defendant is the only person in this courtroom and who testified who has the ability and the motive to do so and the reason to do so. And as far as Ms. Newman would like to paint Isabella Tagliarini as some sort of manipulative person, this is a person that witnessed somebody being bludgeoned to death right beside her. And she testified. And testimony, ladies and gentlemen, in a murder trial is evidence. Can't get around that. There's the physical evidence, what he did, which car he drove, him giggling at the dump. But her testimony is evidence. And you can give it any weight you want, but it is evidence, ladies and gentlemen. And I will proffer to you that after hearing all the evidence and using your common sense, that's all I ask. You should find the defendant guilty of murder in the second degree. Thank you.
All right. We're going to break for lunch now. And let's plan, excuse me. Let's plan on getting back together at 1:30. At that time, I will instruct you on the law. Please leave your notebooks at or by your chairs. And a reminder, don't discuss this case with anyone, not even among yourselves. Don't do any research. Go to any places discussed during the course of the trial. And of course, avoid anything in the media that could be related to the case. Everyone have a good lunch. I'll see you at 1:30. Again, reception area here on the 5th floor. All right, we're outside the presence of the jury. You may be seated. Anything else that we need to discuss before we break for lunch? All right, I have the final draft that I received from the state of the jury instructions. Any corrections or modifications before I have them printed for the jury?
No.
All right, then that's what I'm going to do over the lunch break. All right, we are adjourned until 1:30. The record reflects the defendant is now present along with his counsel and counsel for the state. I have been advised that a verdict has been reached. Are both sides ready to receive the verdict? All right, let's bring in the jury. All right, everyone may be seated. I have been advised that the jury has reached a verdict. Is that correct?
Yes.
All right, we can have the verdict form. Please hand it to the bailiff, please. Thank you. All right, if the clerk can please read the verdict.
In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, State of Florida, Eric David Robinson defendant, case number 17-11373, CF-10A, Judge Bernard Bover. Verdict. We, the jury, finds as follows to the defendant, Eric David Robinson, in this case. The defendant is guilty of murder in the second degree as charged in the information. If you find the defendant guilty of any of the crimes listed above, you must answer the following questions. During the course of the crime committed, did the defendant, Eric David Robinson, actually carry, display, or use a weapon? Yes. So we say all this first day of May 2023 at Fort Lauderdale, Broward County, Florida, with the four-person Rita and
All right, let's hold the jury. If do you have their notebook numbers? Let's go by that.
I do not.
You do not. Do you know which ones were returned to you?
it was tossed out. 7 was returned to me. I think we're keeps the books now.
All right, let's go by number, and the one that doesn't answer, we know that's the one that was excused.
Yes. So we go by numbers.
Just go by juror numbers. We're going to go by notebook numbers. All right. Go
Okay.
ahead.
Juror number 1, is this your verdict? Okay. Juror number 2, is this your verdict? Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict? Okay. Juror number 6, is this your verdict?
Yes.
Juror number 7, is this your verdict? And juror number 8, is this your verdict? Yes.
Okay, all 6 jurors have answered in the affirmative. The 2 numbers that weren't answered to, the 5 and the 7, were the 2 alternates that were excused. Do we have? You have their phones, correct? Okay. When I excuse them, you can take it in the back and just hand them the phones there. I do have certificates of appreciation. If we can trade these for their juror badges, because we do recycle those. Okay, he'll pass them out to you, those certificates, when you get your phones back, okay? One last thing before I do discharge you, I do have an instruction to read to you. The instruction reads as follows. Members of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. The bottom line is this: all those restrictions that I put upon you earlier are now lifted. You're free to speak to anyone that you want to. You're also free not to speak to anyone and to maintain your privacy, and I'll leave that decision up to each of you individually. Again, I thank you for your time and effort expended on this case. I know you took your responsibility very seriously, and I do thank you for that. At this time, you are discharged from your duties as jurors. The deputy will take you out back and return your devices to you and give you those certificates. And again, I thank you for your efforts on this case. This time, you may follow the deputy. All right, you may be seated. We're outside the presence of the jury. Let's discuss setting a sentencing date. I am ordering a pre-sentence investigation, so we're going to need at least 30 days for that to be done. Yeah. Well, he's entitled to it, so not a problem. We'll order a pre-sentence investigation on Mr. Robinson. So we're looking at a sentencing date more than 30 days down the road. State have a any sort of conflicts or issues as far as picking a sentencing date?
I'm going to be here for the next 2 months.
Okay. So,
I request, I need a copy of the statement.
all right, we have someone here to print them. We need a set of prints. We need 2 sets, one for the court and one for the state. My schedule for sentencing date.
I just need somebody who's going to take effective to be available at the sentencing, that's all.
Okay, you're going to be taking the prints?
I'm debating between.
I know. Well, who's going to be here between a month to 2 months from now? You're available? Then I guess he'll be taking the prints? All right.
The other option is to bring him back, I don't see, Wednesday, Judge.
You know, I will call with I know he's around all the time. I see him. So I'm sure getting him here won't be that difficult. So let me pick a date sometime in June. I'm ordering a PSI. Let's have a return date of June 2nd on the PSI. And sentencing date will be June 16th. Work for everybody? I'm going to set it in the afternoon, so hopefully we avoid morning conflicts. June 16th. Thank you. Sentencing will be set at 1:30 in the afternoon. See if you remember. All right, well, I will do that. Is there anything else that we need to discuss before we adjourn for today? All right, so the court is adjourned.